So today, webinar is about a question that is very important to me, is the misqualification of driver, and the whole question about who's the operator of the vehicle, whether it's the subcontractor or the original owner-operator. And in the context of that question, I've asked two good friends, Carole and McAfee, Wallace from Fernandes Hearn in Toronto, and Heather Devine from Isaac & Co. Heather is currently serving as the treasurer of the CTLA, and Carole is a former president of the association. So two very bright lawyers with deep roots to the industry, and I'm very proud to have them on the line today. We'll start with Carole, and Carole will speak about the recent change to the Ontario Employment Standards Act and the Fair Workplace Better Job Act of 2017. And then Heather will chip in about the consequences of these changes. Through the conversation, I will try to chip in and provide a Quebec perspective on the question. So the first speaker today, as indicated, is Carole. Carole represents both domestic and international trucking and bus corporation. She do a lot of employment law, both on the federal and the provincial level. And she is also involved in the drafting of contract for independent contractor and owner-operator. She is also doing a lot of compliance issue, whether it be regulatory or not. And I know for a fact, because we share many clients, that she has a very good reputation. So, Carole, I'll pass you the mic.
Thank you very much, Pierre-Olivier, and good afternoon, everyone. And Pierre-Olivier, thank you for that warm and lovely introduction. Just to clarify, I have not served as president of CTLA, but I was a director many years ago. So I just wanted to clarify that.
Oh, you were not. Are you really? We need to make a change to that. You know, they're going to be an election.
So I hear.
So you got to be in Montreal for the annual meeting.
I will be there, and hope to meet many of you there as well. So as Pierre-Olivier introduced the topic, we're focusing today on independent contractors. What does that status mean? What is the consequence if you get it wrong, or if your clients get it wrong? And there was a recent change to the Ontario Employment Standards Act that was brought about by Bill 148, the Fair Workplaces Better Jobs Act 2017. This amendment came into force in November of 2017, and it introduced a number of significant changes to the Employment Standards Act on a wide range of sections to the Act, but we'll focus on the one that brings us here today, and that's the change that prohibits an employer from misclassifying or treating an employee as an independent contractor. And the Act, the part of the Act that's amended is found in Part 3 of the Employment Standards Act, which is the section entitled How This Act Applies. So that section of the Act identifies who the Act applies to. It also includes the provision that an employer is not able to contract out of the Employment Standards Act, and it's in that context that the Act has been amended to add Section 5.1, subsection 1, which we've reproduced on the screen in front of you. An employer shall not treat, for the purposes of this Act, a person who is an employee of the employer as if the person were not an employee under this Act. And so that's how they have created this statutory prohibition against misclassifying independent contractors. Now, this doesn't change the law, because an employer has always been at risk if it misclassifies an employee as an independent contractor, and focus strictly on ESA context. That misclassification would result in potential liability for unpaid overtime, holiday pay, vacation pay, and then what happens when the relationship comes to an end with termination or severance. And Heather's going to get into more detail about the consequences in a few minutes. But what we now have is a statutory prohibition against doing what has always been at risk for an employer. And in addition to the statutory prohibition, the onus of proving whether one is an employee or an independent contractor now rests on the employer. And so we find in subsection 2 that if during the course of an employment standards officer's investigation or inspection or in any proceeding under the Act other than a prosecution, in a prosecution you don't have the reverse onus, an employer or alleged employer claims that a person's not an employee, the burden of proof that the person is not an employee lies upon the employer or alleged employer. So as
Tell me, Carole,
yes.
I understand this is a fairly new piece of legislation, right?
Yes.
So have you seen a lot of movement in the industry on the floor level at this point? Is there like a wave of enforcement, or is this something you feel is the rise is raising?
It's a bit early. I haven't been able to find any evidence that this has been that this section has been utilized. I think what I do understand, first of all, the Ministry of Labor is upping its enforcement workforce. They are hiring up to an additional 175 enforcement officers or employment standards officers, which will almost double the workforce. I do know that they have been very busy on investigating some of the other changes to the Act, being the increase in minimum wage, and we've probably all seen and heard in the media about employers who claim that the cost of doing business is now challenging with an increase in minimum wage, and so they're taking things away from employees like paid breaks and things like that. So I think what's happening in this initial period where the changes have just come into force is that there's some other issues that they're busy with. But I do also think that from a practical perspective, I think astute employers are carefully reviewing their contracts and their relationships to make sure that that they've done a good job of classifying their workforce properly. And I know for my clients, if they are about to enter into an independent contractor agreement, it's a good reminder to really think carefully whether this is, in fact, the way to proceed with the relationship.
Because I understand there will be very stiff penalties for those who contravene to the ASA, right?
Well, that's right. And again, there have always been stiff penalties for a contravention, but we now have this statutory prohibition. So there's now a new offense for not complying with the Employment Standards Act. As well, if there was a determination that one was an employee and not an independent contractor, that's, or there was an order to pay outstanding wages, and that was not complied with, there is this, in Section 132 of the Act, a general offense for contravening the Act or not complying with orders or directions. And as you can see, the fines, if the offender is an individual, it's up to $50,000, and for corporations, it's up to $100,000, and that's for a first offense. A second offense, it could be up to $250,000, and more than one prior conviction could lead to fines up to $500,000. So you're right, the fines are significant, and I do think that the objective behind all the changes to the Employment Standards Act are to strengthen and protect the Ontario workforce. So given all the efforts made by the Ministry of Labour to increase their number of officers, and with these very significant changes, I wouldn't be surprised if they really do pursue tougher penalties. They do on the occupational health and safety side of things, and I think we need to be prepared that will be consistently done with the ESA.
I got to say, I'm pretty surprised by the amount of the fine. I mean, it's worse than losing a wheel on the highway. It's a pretty serious violation.
You're right. You're right, it is. I mean, thus far we haven't seen, as I said, not like under the Occupational Health and Safety Act where the fines there are very high, not just for serious injury to workers, but even sort of non-fatal or non-serious injury, the fines are very high under that act. Not so much with the ESA, but given the range, and as I said, given the objective of this amendment, we'll see what happens. But the ability is there for a prosecutor to pursue the high fines.
Excellent. And what happens if you do get convicted?
The Ministry of Labor is going to publish the names of employers who do not meet employment standards, and that publication will include the nature of the noncompliance, when it occurred, and the penalty imposed. The ministry does that now with occupational health and safety prosecutions, so even if you don't have reported decisions, even if you've done a plea bargain, and you enter your plea on agreed statement of facts in court, the Ministry of Labor will release a press release, and they're collected on their website, and they contain this very information for occupational health and safety violations. So they're going to do the same with violations under the ESA. I suppose twofold: to act as a deterrent for others to understand what the consequences are in terms of penalties, as well as reputational consequences for an employer who's been cited for not meeting what we have to remind ourselves is just the minimum employment standards that an employer is obligated to meet.
And let's take a bet today. I will not be surprised if in the near future sophisticated shipper will include a provision in their contract saying that they will not contract with people listed in that registry. I mean, we're already seeing provision that carrier undertake not to have child working for them. I'll be very curious to see how that registry get into contracts. I mean, it's a pretty serious consequence to be listed in the public registry like that.
Sure, yeah. I mean, you're absolutely right. I find that too with, if you look at human rights matters. You have clients who are subject to human rights violations, and one of the things one has to keep in mind is one's reputation. So even if one is not certain that there has been a violation, do you really want to go through a public hearing where there's a record, a decision, and if there's any risk that the result could be in favor of the employer, why risk the damage to your reputation if you're able to resolve it? So you're right. All of these things are important factors for an employer to consider when treating its employees or independent contractors. Because, as I said, these are just the basic statutory minimum requirements. Many employers will offer more generous workplace terms, and this is just the bare minimum. And of course, not treating independent contractors, not treating people as independent contractors to avoid, having to remit taxes, having to maybe provide benefits, having to pay overtime. So you're right, it's a good incentive to really think carefully before one just labels somebody an independent contractor.
So tell me, Carole, when you draft a contract for owner-operator, is there like a legal test or some kind of golden rule you can follow not to fall into pitfalls?
Well, there's let's start from the other end. When things go bad and an independent contractor now wants to challenge the classification, both under the Canada Labour Code, so for many of our clients who are federally regulated, they will be subject to the Canada Labour Code, as well as proceedings under employment standards. The test that the adjudicators rely on is the one in the Supreme Court of Canada decision, the numbered company versus Sagaz Industries, back from 2001. That case is still being relied upon for the test, and the test is really not, as the court said, there's no universal test. There's a bunch of different tests over the years with different labels, but really the central question comes down to whether the person is engaged to perform services as a person in business on his or her own account. And it really does focus on the level of control that the employer has over the worker's activities. And what the Supreme Court did in the Sagaz case is it did list some key features. We sort of usually have them boiled down to four things. Control, who owns the tools and equipment used in the work, so whether the worker provides his or her own equipment, whether the worker hires his or her own helpers, what's the degree of financial risk that the worker takes, responsibility for investment and management, how much does the worker have, and does the worker have opportunity for profit in the performance of his or her tasks. So the Supreme Court said... The incorporation
is something to be looked upon?
Sorry? Is
the incorporation, is that like a definitive firewall, or...?
Not at all. Not at all. I mean, it's definitely not determinative, and there's a case that I've cited in this slide that we have up that's from 2017, and in fact there are many, you'll find many cases. This was under the Canada Labour Code, a wage recovery proceeding, where the owner-operator had in fact incorporated. He collected HST, but the court looked at that and said that's not enough. Certainly, when we're drafting contracts or helping our clients set up a relationship with an independent contractor, it certainly is helpful if they're incorporated or operate under a business style, but that's not determinative. The real and also, the parties can set up a contract where where it's clear, the parties agree that this relationship is one of independent contractor, not employer or employee. Again, that's not determinative, but it does show that the parties have identified what their intentions are. So some of the cases that we're seeing with the unsophisticated owner-operators, they might be sophisticated enough to incorporate, but they don't insist on having a written contract that sets out all of the terms to the relationship. So we you want to have a contract. You want to have clear language that identifies the nature of the relationship. I've seen it, and I think the Singh case was one where the owner-operator didn't even own the truck. The carrier owned the truck, and that I think is pretty well fatal in the owner-operator relationship, because the tool of the trade is the truck, and that's if the owner-operator doesn't even own that, then I don't see how they could be determined to be an independent contractor.
So I understand, like, every case is different, and it's always a question of the pattern of facts, but what if the owner-operator is operating under the CVOR of a larger carrier? Would that be something more with more weight?
I don't think so. I think that I've looked at this in the workers' compensation context and have been involved in those proceedings where the appeal tribunal is trying to assess an owner-operator-carrier relationship and whether it is one of employee or independent contractor. And so I think that the fact that the independent contractor works under the carrier's CVOR, I don't think that's determinative. I do acknowledge that the challenge there is that the CVOR holder, the carrier, does have to exert a certain amount of control over the owner-operator because of the CVOR holder's obligations to ensure that hours of service are not violated, that pre-trip inspections are properly done, that the owner-operator's truck is properly maintained, and that evidence of that maintenance is provided to the carrier. So there's a certain amount of control that a CVOR holder will have to exert over an independent contractor. And I do think that there is a certain understanding in the workplace compensation world that has to exist for regulatory reasons. But as long as your contract also provides for, it doesn't include things like, it should provide the ability to refuse loads. You're not promising any certain number of loads. You don't need permission to take time off. I've seen that where the word vacation has been put into the agreements. That's not helpful.
You must avoid using an employment contract and just changing the title.
Exactly. Or even, and you have to be careful with discipline. Again, you want to make sure your owner-operators are complying with the regulatory regime. So what's the consequence for non-compliance? You want to make sure that's drafted in a way that's more a breach of the contract terms as opposed to disciplinary type of language. As you said, you can't use employment type language or concepts and just simply change some words and use them in the independent contractor agreement.
I'll give you all an example. In Quebec, section 2 of it's in French, but it's Act Respecting Owner, Operator, and Driver of Heavy Vehicle. And Section 2 defines what is the operator. And it's very similar in some way to 16.1 of the Highway Traffic Act. And both define the operator as the person in control. In Quebec, there is a somewhat very famous case called Roi Livraison Spécialisée. It was argued by our colleague at Robinson Shepard Shapiro. Normand Laurando was the attorney making the case. And it's a case that went to the Court of Appeal for the Quebec Transport Commission, so it's the administrative tribunal. And in that case, it's a brilliant case. It says it's not because you're the operator that you're necessarily the employer. And the essence is that you may be, because of the regulation, forced to control the quality of the work, because as the operator you must be in control. But if you control the quality, you may not dictate how to do it. You just make sure that the work is properly done. So it's a whole different world than saying you must do it in such and such a way. So in a contract, you can talk about disqualification. You must avoid talking about termination or suspension and so on. So the Roi Livraison case is a very, very good example. What about the dependent contractor?
Yes, this is an emerging category. We've had 2 Court of Appeal level decisions here in Ontario. I do understand there's some cases out in BC. And it's a sort of a hybrid or a halfway point between independent contractor and employee. I'll just briefly take you quickly through the 2 cases. McKee and Reed's Heritage Homes Limited, that was the 2009 Court of Appeal decision. Elizabeth McKee, she had an incorporation, and through that incorporation, she sold homes for the defendant Reed's Heritage Homes. She did so for a period of 18 years. She hired employees and agents to work under her corporation, and her corporation paid them. The defendant company was bought by a new owner who wanted to make McKee an employee. They never could agree on the terms of that relationship, and so they terminated the relationship, and she sued for wrongful dismissal. And the trial court found that she was an employee because the work she did for the defendant had become an integral part of Reed's Heritage Homes business. They, of course, then appealed that determination to the Court of Appeal, and the Court of Appeal examined the relationship and concluded that there was an intermediate category between employee and independent contractor, and that this intermediate category existed where there was a certain minimum economic dependence that was shown through either a complete or near complete exclusivity, and that would mean that someone was a dependent contractor, and that if one was a dependent contractor, they were entitled to reasonable notice of termination of the relationship. And the Court of Appeal went on to look at the Sagaz decision in the Supreme Court that we talked about a few minutes ago as being an applicable analysis for distinguishing between an employee and an independent contractor, and that it would apply equally to trying to distinguish between an employee and a dependent contractor. And once it was clear that someone was not an employee, it was then necessary to determine whether they were independent or dependent, looking at exclusivity and economic dependence. Now, the Court of Appeal in that case, while confirming that there was this dependent contractor category that existed, it found that Ms. McKee was an employee and she got notice of termination. In the Keenan and Canak Kitchens case, Canak Kitchens has had many cases reported because of their, I would say, challenging or less than reasonable treatment of employees. This case was one where the husband and wife team worked for the company for many years, and in 1987, Canak ended the employment relationship with them and moved them into independent contractor status. And they continued to do the same work. And they did so exclusively for Canak until 2007. Then there was a slowdown in the business, so the Keenans began to work for another company doing similar work, but the majority of their income still came from Canak. And then in 2009, they terminated the agreements, and because they were independent contractors, they gave them nothing. Now, at that time, Mr. Keenan was 63 years old and had worked for Canak for 32 years, and his wife was 61 and had worked for 25 years. So they sued for wrongful termination. And in that case, the trial court found that they were dependent contractors and gave them each 26 months' notice. Canak appealed, and the Court of Appeal looked at the full history of the relationship. Canak and acknowledged that for 2 years before termination, while the Keenans didn't work exclusively for Canak, if you look at the entire duration of the relationship, that 2-year period of non-exclusivity was relatively short in the total context, and found that there was near exclusivity such that there was economic dependence, and upheld the finding of dependent contractor.
So essentially, they were entitled to notice of termination like an employee.
Well, that's right. And that really is, in the common law cases, the real consequence of the finding of dependent contractor is that the individual now is entitled to a notice of termination that would be equal to what an employee is entitled to. Thus far, that's all that courts have been prepared to award a dependent contractor at the end of the relationship. The only other thing to keep in mind about this category of dependent contractor, in both the Canada Labour Code and in the Ontario Labour Relations Act. In both of those statutes, the Canada Labour Code Part 1, which deals with unionization of employees, the definition of employee includes dependent contractor, and dependent contractor is defined to include this concept of economic dependence. So that's the other potential consequence of a dependent contractor finding that that individual may be eligible to participate in collective bargaining.
What is the consequences of not owning the vehicle in Ontario? Is that making a whole difference, or?
For dependents, I think that, the problem with the not owning the vehicle, I think that if you go back to the approach in the McAfee case, you first have to decide, is someone an employee or not? Is it an employee or an independent contractor, looking at the SAGA's decision? And I think if you don't own the vehicle, you don't own the tools of the trade or the tools required to conduct the work. So I stand to be corrected, but I think it would be extremely difficult for one to demonstrate that you are an independent contractor or not an employee, I should put it that way, if you don't even own the truck.
Yeah. There's I'm not going to ask Natalie because she didn't agree to participate, and I didn't give her fair notice of the question. But Nathalie Léveillé of the Quebec Trucking Association is, as I can see, on the line, and the Quebec Trucking Association was really involved with the phenomenon of incorporated driver in Quebec, and seems to be resolving, but it's still a pretty common occurrence to have a corporation with only one asset, which is the driver and his license, and it is a pretty bad idea.
And is that being upheld in Quebec as a true independent contractor type relationship?
Let's say that I strongly urge clients not to do that scheme.
Okay.
For tax and purposes, but also for labor and employment.
Right.
Yeah. Oh, I can see that Natalie is chatting with us and say that it is not being upheld in Quebec. Thank you, Natalie.
Yeah.
Well, thank you so much, Carole. We're 4 minutes late for Eder, but I'll take the blame with my too many questions. Next is Eder C. Devine, partner with the law firm Isaac & Co. Eder and I are both serving on the executive committee of the CTLA, and she's the one holding the checkbook, so I need to be very, very nice with her. She's my acting treasurer. Eder is also a transportation lawyer by trade, and believe it or not, deeply in love with airplane and snorkeling. So, but today she'll speak about road. She's been practicing for over 15 years across the country, and she's been known, and to quote her bio, as a fixer. So, Eder, what to do to fix this?
Well, thank you very much for that fantastic introduction, and I'm certainly happy to go second to Carole because, as we all know, Carole, this is your area of expertise, and I look at it as more a general industry specialist. And what I start with in terms of this comes across my desk is when I'm either being asked by a U.S. company to look at a acquisition in Canada, or of course by our clients who want to stay compliant with the law. So I start with the top 10 changes recently to the ESA, our Employment Standards Act, because if you work backwards, and you'll see that I've highlighted as number 10, the independent contractors versus employees. If you have an independent contractor or an owner-operator who is considered to actually be an employee, then you will find that they are able to claim, as Carole's already pointed out, many of these benefits, all of these benefits from the changes to the ESA. And so if we go to the next slide, you'll see as as already reviewed in some detail, but from a higher level overview, you'll see that if an adjudicator actually finds an employer has misclassified an employee. So you have to think about, what does this mean for our clients? It means that you may have a company that may not even be a carrier as its first business. So let's say you have a construction company, or you have a paving company, for example, and they have a blend of employees and owner-operators that provide services. If, under this new test, with this new emphasis, because as Carole pointed out, it is emphasizing fair workplace and better jobs act. So the emphasis is already that you can see where they might fall. The implications for an employer that has a blend, for example, of employee drivers and owner-operators may be tax consequences. They may owe retroactively Canada Pension Plan, employment insurance, health taxes, government health insurance. It's a very pervasive implication for an employer who gets it wrong. So if we go to the next slide.
Just before we go further, Heather, when I was talking about the incorporated driver, the big consequences that I fear is the tax issue, and I'm happy to see that it's your first concern as well in the list.
Yeah, because listen, what I find often is a client will call me and say, "This predates these changes. Heather, I've been using owner-operators for years, but the CRA, the Canada Revenue Agency, is now telling me that they're not independent. They're employees. What does that mean?" And the tax consequences alone can be severe.
So for the next couple of slides, I understand you will be taking through three big concepts. The first one is the employment and the minimum wage. It's a bit of a sad story, your maid lady, but I believe we can draw some very good link between this case and the trucking industry.
Well, absolutely, because here we had these are not obviously these are not from the trucking industry, but these sort of give you a sense of the precedent of repercussion. So you get someone, they say no good deed goes unpunished. So it started as a compassionate act, and she was given a fixed amount per room. Well, those of us in the industry know that some owner-operators get paid by the mile, or they might get paid by the haul.
Or by the drop, or by the warp,
Exactly. Because what you've got is a company who contracts with an owner-operator and wants to make it very clear they're not an employee, so therefore has some sort of allocated method of payment that's not consistent, and it's tied to performance. But here we had a similar matter in 2016, and a complaint that the person said, "No, I want minimum wage. I don't want to be paid fixed amount per room." And she was found to be, at that time, an independent contractor by the Employment Standards Branch. So we go to the next slide. And we move forward, though. She's then found to be an employee. And if we look at some of their findings, she wasn't engaged in business on her own account. And that becomes very significant because we'll have owner-operators who are servicing one major client. And she did not advertise her services or have other clients. So that's another finding, is that are your owner-operators looking for other work? Because you might say, well, they were always able to do other work. They weren't exclusive to the company. But then the scrutinization may be, well, what were they doing to get other work? Or did they even have other clients? Here, this lady had the ability to profit, but it was considered limited. So again, if you look at how much your owner-operators are being compensated, you might say, well, the breakdown of their payment, which is by mileage or by drop, encompasses profit for that owner-operator. But the question then could be, is it limited? So you can see how they push towards the finding of being an employee. And there, the employer had provided all cleaning products and equipment. And I agree with what Carole said in answer to you and what Natalie was saying. But here's one of the concerns I have, and it's not tested yet, But many of the trucks that we know are on the road, the tractors are worth sometimes upwards of $250,000. These owner-operators are not buying the trucks outright. They're doing a lease-to-own program. And if you look at that lease agreement, they obviously can't walk away with the tractor without having paid for it, and they're often in an agreement with the company for whom they're providing services. So at the end of the day, if you've got an adjudicator who's predisposed to finding an employee, is the company providing the equipment? It's a question. Next slide. I don't want to take too long on this one. This one, just goes through a bit more of the facts, and we can move. Except the one significant part of this slide is the damages for pain and suffering. And so that too would set a pretty high bar if some of the owner-operators were to get, and as Carole's already pointed out, they're entitled to join a union. So if you get some movement here in Ontario by either employer plaintiff's bar or an aggressive union, you're going to have some owner-operators taking a look at, well, maybe I'm entitled not only to all the benefits retroactively of an employee, but maybe I'm also entitled to pain and suffering.
I can tell you guys that I am not aware of any movement of such a kind on a very large scale in Quebec. What we do see, though, is complaint by employee, truck driver paid by the miles, that are asking for hours and like holidays and such and such. And because the company are paying by the miles, it gets very difficult not to pay the overtime. And for those on the line, one of the best defense to that is to keep track of the logbooks, because it's a signed declaration by the driver of the hours. And often we had case where the actual logbook was a pretty strong argument against the fact that we had to pay overtime because the driver had declared such an amount of time he had to work and drive on the day. So let's not destroy the logbook after 6 months as per regulation.
That's an excellent point. Here's another one, though, where the court found the individual was an independent contractor, and as Carole has said, you can try to capture the intention of the parties in the agreement, and then, one looks at the conduct. So that's a recent case, but again, it predates the changes that we're looking at. We can go to the next slide. And so I've given here some of the findings. And as Carole has set out on her slide, it's the control test, but these are the findings where they're looking at the control test. So they give a good guide to trying to figure out whether you'll fit within the independent contractor mode. And here, as you would have someone who owns their own truck, or as much as they can purport to own their own truck, they definitely should have an incorporation number and be registered and be paying those fees so that they have a CPR corporate profile report and a corporate number. They should be paying their own insurance and pension contributions. The company should be giving them a T2, and the owner-operator should be filing their own taxes. And then
so all these are very good tips to include in your contract if you were to draft one.
Yeah, exactly. So what's interesting is the way you've combined Carole's presentation and my own is that these findings meld exactly with what Carole is recommending that you do. So, for example, here's a finding where this lady was an independent contractor because she had not been promised any minimum amount of work. So any contracts you have with your owner-operators, scrutinize. Are you requiring them to be exclusive, or are you encouraging them to offer their services to others and do not promise a minimum amount of work? You can go to the next slide. So pay equity is also an issue. I don't know how much of an issue and how much time I would spend on it. There's so few lady drivers, but for the lady drivers that there are, if there are different payment schedules for them, and they've complained that they're an employee under this provision, there could be something that you want to be mindful of. Next slide.
Just before we go, I was very interested by that slide, Heather, and I'll tell you why.
Okay.
When the dispatch is done, there's always a question of who gets the best routes, and often it's based upon are you the oldest driver on the list. I am not aware of any cases, but I'll be very interested to see if someday in the future we have a case where a lady say, I'm prohibited to get the best run with the highest yield because I'm a woman, and maybe that's going to be the door for a pay equity case in the future. But
what's interesting is my clients that I've got generally always tell me that they give favorable runs to their very few lady drivers. One, to try to encourage them to stay, and two, to try to make sure they have a route that the company thinks is safe.
And in the Wellington case, what is your view of the fact that they had an agreement that was like in plain English, and where they acknowledged that they were ICs?
I think it's absolutely crucial. We've heard already how important that contract is between the company and the owner-operators. And here, in this case, the tribunal had disregarded the agreement. But, keep in mind, this is an old decision. It's about 16 years old. And, as Carole said, having a contract doesn't mean that for sure they're going to find that there are independent contractors. You really need to make sure that the structure of the relationship between the company and the owner-operators, really does show that control has been properly delegated.
Excellent. Thank you very much, Heather. Very good advice. And I say advice not lightly, but I want to remind everybody that this is an open discussion about the law, and that at some point we might be arguing the contrary of what we just said, because the law is moving and the facts are always changing. So these are guidelines, not legal opinion, of course. I'm really grateful for Heather's and Carole's time. And before moving to the Q&A question, again, another plug for the annual conference. Registration will open June 1st. It is, I believe, going to be an amazing couple of days, starting October 25th. William Gray is a stunning resort. It's a beautiful hotel. It was named as one of the best hotels to open in the world in 2017 by the Condé Nast Traveler. And we've been able to secure very favorable rate. The conference is a little bit later than usual in the calendar because we were trying to get after the ice season in Montreal. There's a lot of CLE that is packed. We're going to try to do a lot of workshop, a lot of 101 sessions, so that if you don't do marine work, you'll get the tool to understand what the speaker are talking about, and for all modes. And again, there will be a special discount for general counsel and in-house counsel, because we do need to have both sides of the medal at the conference. So for the Q&A, I'll now switch in the question and answer mode. If you want to ask a question, we do have time in front of us. Simply dial 6 to speak. And while people are gathering their questions and the courage to ask them, I'll remind you that this is currently being in the process of being recognized by the Quebec Bar for 1 hour CLE. You will receive a survey at the end of this conference around 5 o'clock sharp. And upon completion of the survey, you will receive the certificate of participation for the CLE. It is very important that you do complete the survey, because it's the only proof that under oath you affirm that you attended the whole webinar. And also, I want to point out the next deadline for TTL is May 15. You may contact Jean-François Bilodeau at the number on the screen if you want to provide a paper. It is a very good opportunity for those who want to write on the question and try to influence the evolution of the law, because that TTL magazine is distributed to about 1,000 attorneys in North America, including about 5 in Mexico. We love them. and it is a very good way to influence the evolution of our practice. Finally, before taking any question, I strongly urge everybody on the line to join or have somebody at your firm join. We need more people. We need younger women. We need younger attorneys to join us. It's very simple. You go to CTLA.ca. It's, I believe, fairly cheap for what you get. These free webinar and the TTL you receive 4 times a year. So join us at CTLA.ca. So if there's any question, I'll be happy to take them.
Pierre-Olivier, it's Carole. While we're waiting for questions, I also thought we should remind ourselves of another potential for fallout if someone had been treated as an independent contractor and now is claiming that they're an employee. If they're federally regulated, then we've got to deal with the atomic energy case out of the Supreme Court of Canada from a couple of years ago, where the Canada Labour Code has been interpreted to provide that an employer cannot terminate a non-managerial employee who's had 12 months of service or more unless there's just cause or elimination of the position or lack of work. So for those federally regulated employers, there's also this risk that you might not even be able to get rid of them if they're determined employees.
Excellent. So seeing that there's no question on the line, I would again thank you. Oh, yeah, sure. Go ahead.
Hi. It's William Tackaberry.
Hello, William.
Just this afternoon, I was meeting with a client of mine who's a carrier who's being sued by whether dependent or independent contractor, but he operated as an owner-operator with his own tractor being provided, and of course the trailer was provided by the carrier, and he is attempting to include in his claim 2 weeks' notice that wasn't provided, allegedly, but at his owner-operator rates and not necessarily a portion that's an employee as opposed to an owner-operator. You know, maybe I'm not explaining myself very well, but very simply put, you know, if an owner-operator gets $2 a mile to drive and a company driver gets 50 cents a mile to drive, should he be entitled to any notice? And if notice, should it not just be that portion of him where he's actually driving as opposed to his equipment? Do you follow what I'm saying?
Sorry, William. I don't know if we have a very hard time to understand you.
Okay. The claimant. Hi, can you hear me at all? Because I'm having a hard time hearing you.
I can hear you now.
Okay. So there never seems to be any kind of a breakdown when, like, for example, when the labor board says, no, even though you have your own tractor, you're still deemed to be an employee because, you know, you're under the control of the carrier, you have to accept loads, et cetera, et cetera. So the question was that, you know, when a claimant attempts to claim for lack of notice because now he deems himself to be an employee as opposed to an owner-operator.
Hey, William, sorry, what is the last number of your digit of your phone number?
That I'm calling you from?
Yep.
818? 8585. My apologies.
85. I'm just gonna mute everybody else but you. Okay, so William, what you'll do is dial dial *6 in a second, okay?
Okay.
Okay, you can dial *6 now, William.
Okay,
is that better?
Can you hear me? Yeah.
Okay, that's
way
much better. Yeah.
So, yes, so here's the scenario. So they're being sued, and the claimant is attempting to suggest that he didn't get 2 weeks' notice under the Employment Standards Act, but he's attempting to claim the revenue that he would have got as an owner-operator as opposed to an employee. So, in other words, if in a 2-week period he would have grossed $7,500 because at let's say $2 a mile. What are the panelists feeling with respect to that? It seems like the Labor Board and certainly the federal labor people seem to be leaning more towards saying that owner-operators now are in fact dependent contractors.
Well, okay. So first of all, as indicated earlier, it's very hard to give an opinion. So let's talk about the reaction by the panelists. And more importantly, we don't know who's the carrier, so it might be one of our clients. So let's be very careful about what we say on the line. I believe that if you look at what was said today, it's all a question about the facts. And I really did like one of the slides where it was indicated about the question of control. So every case is going to be different. It's all going to be all about the facts and can be boiled down to a question of control. And if, and I say if, the subcontractor is able to get recognized as an employee, then as per the comment that we made today, he'll get the same termination process as any other employee. Heather, Carole, are you the same line as me?
Yeah, I agree with you, yes.
Yeah. So case by case, and hopefully it's not going to be one of our clients.
Yeah, and if you look at the cases where it was dependent contractor, the Canac Kitchen case, they were awarded, to the best of my knowledge, their award was based on what they had been paid as, quote, independent contractors. They got that notice period. So I if there's a finding they're an employee, then you look at what their earnings are, if they're allowed, if they're an employee or a dependent contractor, if they're an employee, if that's the finding, well, then they'd be, whatever award would also be subject to statutory deductions.
So the Keenan and Canac Kitchen is 2016 ONCA 79.
That's right.
Okay. Anybody?
I guess my final sort of follow-up on that would be, how do you, if a carrier employs only owner-operators, and how would anybody make a finding as to what what portion of that would be as an employee and what portion of that would be towards the operational cost of his vehicle? And I don't think that's what these labor boards have in fact been able to drill down on. So if all his paychecks were always $2 a mile, who's to say that the employee rate involved in that $2 a mile is 40 cents, 50 cents, 60 cents a mile?
We have Kenneth on the line. I do feel like a radio host. That's pretty cool. So Kenneth on the line. If you want to dial *6, you've made a pretty good comment on the chat. I don't know if you can do that or not, but Kenneth on the line says, "Oh, hi, Kenneth.
Hi, how are you?
Where are you calling from, Kenneth?"
From Toronto.
Hi there.
Good to speak with you on the air, so to speak. As I was understanding the question, the argument was that if an individual has succeeded in being described as an employee and therefore entitled to some minimum notice of termination, how do you calculate the loss or damages? And it was my view that surely, you can't have it both ways. You can't seek to recover gross revenues that might have been earned if the routing had continued for a couple of weeks. But surely it would be some form of more reasonable net sum after expenses and deductions. and net of provision for mitigation.
Yes, because at the end of the day, we need to evaluate the actual loss, not the actual loss of revenue, but the actual loss of profit, I guess.
Right. So I think that if I was hearing the question correctly, that was the dilemma as to how the loss or damages might be calculated in such a case.
Well, it's going to be a very interesting litigation because the plaintiff will have to open his book and to provide a fairly deep level of information in court so we can evaluate the actual loss. It's not, I mean, if the paycheck is $2 per mile, but then he has to assume the cost of operation, I'm not going to pay $2 per mile. I'm going to pay whatever is left after he paid everything, I guess. Very good comment, Ken. Thank you very much.
Welcome.
Yeah, thank you, Ken.
So for those who just please redial *6 to mute your line to make space for somebody else. Is there anybody else who want to join? One of the questions that I had is because we have a visual per se in Quebec and Ontario, but what's happening in the rest of the country? Anybody outside of Quebec and Ontario to chip in on the question? Is there, to your knowledge, enforcement waves or let's say a trend in the market, or even better, reported cases or unreported cases about the question that CTLA members should be aware when drafting and dealing with the contract and dealing with litigation? So if somebody has a gold nugget, I'll be very interested to have you dial *6 and speak to us. So no gold nugget. So in a sense, it's pretty good news because it means that we were on par with the content today. Again, really grateful for Heather and Carole's time. You did so that I included another bio. I didn't took the time to talk about Hannah. Hannah is working with Heather. She's been doing a lot of work behind the curtain. So. Also very grateful for Anna's work. I know that preparing for such a presentation is not small work, and it's all non-billable hours. So really grateful for all you girls for getting involved today. There's going to be a webinar in the future, free webinar for CTLA member and friends. And when you're going to get the survey, please make sure to include your ideas for future webinar, because we need to be in line with the preoccupation of the membership. So without further ado, it is 4 minutes past the actual hour that was set up for the call, so I don't want to get hold you any longer on the call. Thank you very much, and make sure to come and join us in Montreal in October for the annual conference. Thank you very much, everybody. Have a good day.
Thank you. Bye.
Thank you.